Hi, everyone. Thank you for joining today's webinar, How China is Changing the Global Patent System. I am Gail Martin, Associate Marketing Manager at LexisNexis IP, and I want to welcome you to today's event. A few things before I introduce today's presenters. First, please submit any questions you have during the webinar by using the Questions tab in your console. You can also download a copy of today's slides in the Handouts tab. Also, a link to today's recording will be sent to you following the webinar. We're happy to bring this webinar to you in partnership with IPWatchdog.com, and I'd like to introduce our panelists. Today's moderator is Gene Quinn. Gene is a U.S. patent attorney, the founder of IPWatchdog.com, and a top 300 IP strategist. He has been recognized by IAM Magazine as one of the top IP strategists in the world. Regarded as an expert on software patentability and U.S. patent procedure, he regularly advises attorneys and clients on patent matters, litigation strategy, and appeals. Joining Gene today is Robert Green Stern. Robert is a founding director of Stern, Kessler, Goldstein, and Fox. At the age of 26 and just 1 year out of law school, he set out to create a different kind of law firm. Now, nearly 4 decades later, Stern has helped to nurture and grow this revolutionary idea into one of the top 5 largest intellectual property specialty firms in the country. In fact, Rob has been recognized by the Financial Times as one of the top 10 most innovative lawyers in North America, by Law 360 as one of the top 25 icons of IP, and among the country's IP trailblazers and pioneers by the National Law Journal. Since 2017, the Legal 500 recognized Rob as a leading lawyer in the U.S. for reexamination and post-grant proceedings, a distinction awarded to only 10 other attorneys in the entire country. He's highly respected by his peers and has received some of the most prestigious awards and rankings for professional excellence in intellectual property law. We're thrilled to have both Gene and Robert with us today. And with that, Gene, I will turn it over to you.
All right, thanks a lot, Gail, and thank you all for being here and spending a portion of your day with us today. And if you do want to access these slides during the presentation, you can get them on the Handouts tab if you're listening to this on the computer and you have access to the GoToWebinar control panel. If you're in a conference room setting, lunch and learn type situation, the person who registered will get emailed these slides along with access to the webinar recording, and please feel free to share those with the others who are in the room listening to this today. So I appreciate you all being here with us today, and you maybe hear my voice is a little bit different than it may normally sound. I've been hit with a sinus infection, so I will champion through this the best that I can. And I'm glad to have Rob with us today. And I've tried to get Rob on one of these webinars for a very long time, and I'm glad to have him here finally. Thank you, Rob, for joining us today. I want to pause here at our agenda. And the agenda, for those of you who haven't caught on or haven't maybe searched this topic on IP Watchdog, is brought to us by an article that Rob wrote on IP Watchdog, and the link will be in some of the slides that come up. And the link, the article rather, was titled the same as the webinar today, How China Will Fundamentally Change the Global IP System. And I wanted to talk about this because I mean, this is a topic that I think is near and dear to a lot of our hearts, and we see what's going on with the US system and what's going on in the global systems. And I think some of our advice is or should be changing with respect to what we're telling our clients. And Rob, I want to bring you in at this point, generally speaking, before we jump into the slides and the meat of our presentation. What is it that you want people to keep in the back of their mind about China, about the global IP system, as we start our conversation here today?
Well, I don't know if you all can hear the fire engines in the background here in Washington, D.C., but essentially the Chinese are coming. If you were to use the Lexington Concord analogy for the U.S. and the revolution, the Chinese are coming, the Chinese are here in the global intellectual property world, And it behooves each of us who are providing strategic advice and implementation of IP strategies for our clients to understand what's happened and what is going to happen in the next 18 months. And when I started to dig into this about 3 years ago, I thought I knew something about China, and I thought I knew something about the impact that China was going to have over the next 10 years. I had no appreciation, frankly, about how rapidly things were going to evolve. Just the enormous effort and financial involvement that China has attached to intellectual property in the last 18 months is staggering when you consider how long it takes for the US or for the Europeans or the Japanese or the South Koreans, for example, to evolve their patent system, Gene, and then you look at what China's been able to do in months, whereas it's taken almost decades. For example, the unified patent court that we've been hearing about in Europe probably will not come about because of Brexit, but it's been 25 to 30 years in the making to get the unified patent court to the point where it almost came into being. The Chinese, in contrast, would probably do that in 6 months based on how they've evolved their court system. So I think it's very important that we have a frank conversation today about what's happening and what could happen so that we're all better informed about what to tell our clients and others.
Yeah, it's what's going on in China is nothing short of remarkable. Now, obviously, China is not the panacea in that it's not like Shangri-La. I mean, it's not perfect, it's not ideal for a number of reasons, but let's recall that this is a country, right, Rob, that literally had no patent system, and now they're to a large extent poised to take over the IP systems of the world.
Yeah, and you know, I have this weekly newsletter, Gene, as you know, Focus 2019, and I'm putting it out. It comes out every Wednesday, and tomorrow I'm dealing with China again, and one of the pictures that I'm including in this little short newsletter is a picture of Mao's little red book. This is a really small little red book that everybody in the Cultural Revolution in the 60s was required to carry. It fits into your shirt pocket, man or woman, and this little book is in English, my version, and it's fascinating to read where China's head was at, so to speak, in the 1960s, and then compare the Belt and Road Initiative that President Xi of China has implemented in rapid fashion in the last 36 months, and to compare the impact that the Belt and Road Initiative and the Chinese patent system and IP system is going to have globally and in the next 2 or 3 years. And we need to all get a much better understanding of how this fits together and what's coming, because if we don't, we're going to be in a very uninformed place.
Yeah. All right. Now, Gail, let's push one of the poll questions if we can. Can we do push are you advising your clients to pursue rights in China, so we can get a sense of who it is that we have here and what it is that, or maybe I need to do that. Let me see. Or no, there we go. So I guess poll in progress. So this will just give us an idea of who we're dealing with here, Rob. It's are you advising clients to pursue rights in China? And currently it's almost 70% yes and about 30% no. And while we're wrapping this poll up here, Rob, do you want to tell us a little bit about the Belt and Road Initiative?
Yes, there are historical analogies to this. It was a trade route in the 1400s, 1500s between China and Europe, where all the countries along the way were involved in this particular trade route. It was bidirectional. Certain goods were coming in from Europe and India and other countries along the way into China, and China, of course, was sending goods to pay for this, and vice versa, back into those markets. This was a very big initiative of China around the time of the Renaissance, and had a big impact on Europe. The Belt and Road Initiative that Xi has pushed very hard since 2013 is unbelievable in its magnitude. There are 62 or 67 countries, depending on how you want to count it, along the way. And this is basically a combination of sea routes and overland routes involving railroads, highways, and telecommunications, high-speed telecommunications facilities. And it extends all the way to Italy now in terms of an Italian port, and also by train to the middle of Germany. So, for example, I was told by a colleague in Munich that if you ship product from, say, Beijing, it will be in Germany in containers within 14 days over railroad. And so essentially it is a rapid expansion of the Chinese market. So you're no longer dealing with 1.3 billion people in China as consumers, but you're also dealing with all the countries along the way and the access into the EU. And as we'll talk about more, the Chinese are studying, I have been told, using very informed professors and others, the intellectual property regimes of all the countries along the way. And we can expect that the Chinese will be looking at the intellectual property aspects of this larger global marketplace, as well as the intellectual property aspects for their own home market. So it's a very significant symbiotic situation where IP is part of this larger commercial venture. And the amount of investment that has been made in this initiative in present currency is larger than was put forth to Europe by the United States in the Marshall Plan. And there are estimates that the Chinese will invest 1.3 trillion US dollars in this effort in the next several years. So you can imagine the soft power diplomacy that such an investment will bring.
Yeah, yeah, that is remarkable, and that is quite the initiative, and it ties into the innovation, obviously, because for a variety of reasons, because now the marketplace is matching the back end with the production. And we'll talk about that. Gail, I can't seem to figure out how to get control back here to move to the next slide. Is there?
Yes, we'll work on that.
Oh, I guess well, okay. I don't know whether, oh, there we go. It looks like okay. So the next slide here that we're looking at is the US filings in decline. And this is something that I put together based on WIPO data, and it shows that at a time when the rest of the world, almost all the rest of the world, with the exception of the UK and the US are really the only places that are seeing a decline in filings. In the UK, you might be able to explain that because of the uncertainty with Brexit, etc. But everywhere else is seeing an increase, and in some places a dramatic increase, like in Pakistan and the Philippines and places like that. And you're even seeing increases, a double digit. I don't think I have it here in this paragraph. Double digit increases in Africa and in Vietnam. And then in China, they grew by almost 12%. Now, and those numbers are already extremely high. And when you're growing by 12% in China, patent filings, that's incredibly important. I mean, so you're starting to see two ships, I think, passing in the night. And that goes back to, Rob, when we saw in the poll numbers, 30% of people, at least on this call, are not yet advising clients to get rights in China. I don't know whether everybody should be getting rights in China, but I do think that attorneys all of us should be advising clients about the pros and the cons of getting rights in China. Would you agree with that?
I would absolutely agree with that, and that's what I'm telling everyone. You have companies that are not dealing with the China market. They have no intention of going into China for legitimate reasons or because they don't have the size or the capability or all kinds of reasons. And therefore, the idea that, well, we're not going to worry about getting protection in China because we're not operating in China may be short-sighted. For example, what people don't realize is that the bulk of this incredible filing surge in China is Chinese filing in China. And it's not just utility patents, Gene, but it's utility models, massive filings of utility models, similar to utility models in Germany, for example, which is an area of patent law that many of us in the US don't fully appreciate the difference between a utility patent in Germany and a utility model, but they have the same dichotomy in China between utility patents and utility models because the China patent system is modeled after the German patent system. The examiners at the CNIPA, which is the new name for the SIPO, which is the China Patent Office, were initially trained in the 80s by the examiners in the German Patent Office for historical reference. So in many ways, the China patent system is very similar in structure and operation to the German patent system. So one tip that we all need to take is the more you understand about the German patent system, in my experience, the more you will be able to use that as an analog for the China patent system. But there's also a massive number of design patents that are filed in China. And as you pointed out, Gene, in your announcement for this webinar, there are economic incentives that the government has made for Chinese to file in China, which we need to talk about. But the point is, this massive creation of filings needs to be understood both in an offensive and a defensive manner by anyone who's operating today, even in regional markets, because of the internet. The internet essentially allows for products and services to be sold globally, even if you don't have a physical presence in these other markets. And similarly, the internet allows for hacking and trade secret misappropriation and other aspects that are very detrimental to innovators from afar. And therefore, going back to your original question, should people be considering filing in China? I think the answer is yes, in many, many more circumstances than is currently the case.
Yeah, I would agree with that. And if you've heard Judge Rader talk, and unfortunately, Judge Rader was unavailable to join us here today on this topic, which many of you know, this is a topic that's near and dear to his heart, and we hope to get him to join us on another webinar to discuss these topics here in 2020. But if you've heard him talk, and I've heard him talk on this recently, he's said that in China, being a patent owner is a really good thing to be. Obviously, if you're trying to enforce your rights, there's not 100% chance that if you're victorious, you're going to get an injunction, but it's pretty close to 100%. If you take away the situations where the state may have an interest, or there's really real public safety issues at stake, it's 100%. So it's like in 96, 97, 98% of victorious patent owners in China are getting injunctions. And China seems to be wanting to be seen as patent owner friendly. And that message has gotten out to all of the judges. And now, for better or for worse, China is a one-party rule system, and that's probably something we need to at least acknowledge or talk about for a minute here, right, Rob? And that's one of the reasons why they can make these changes seemingly overnight, or at least at light speed in comparison to the EU or the US, for example.
Yeah, I mean, if you think about it, Gene, they don't have to go through the notice and comment rulemaking process. They don't have to get bipartisan support. They don't have to really allow certain industries to block other industries in terms of their intellectual property system. I mean, the whole purpose, if you look at their 5-year plan, where they've targeted the top 25 technologies, the leading edge technologies in the world, as their goal of being the real innovation leaders in those areas in the next couple of years. You know, the intellectual property system goes hand in glove with that approach in their 5-year plan. If the Chinese innovators, who are no longer going to be effectively imitating others, but being the innovators themselves on the global stage, therefore, the corollary of that is that the Chinese intellectual property system has to be able to protect that innovation and that investment by those Chinese innovators. So if you will, it's very similar to what we saw with the creation of the Federal Circuit back in 1982, where Japanese competition and other non-US competition drove the creation of the Federal Circuit, the strengthening of the US patent system. I think there's a strong parallel between that in the US and what's happening in China today with their patent system, which in many ways looks like what we had back in the 80s in terms of the courts and things at the patent office and the broad interpretation of statutory subject matter and the like. So,
right. And there's also
you know, having
a corollary to go all the way back to the times when of Thomas Edison, right? I mean, maybe these stories are apocryphal, but they get told all the time about how Edison was saying, look, if we don't have strong or stronger rights here in the US, we're not going to be able to make these things, and we're not going to be able to innovate. And that kind of led a different vision, because at some point in time during the US history, the US was the robber country, right? Taking from others during our development. This process of growth that the Chinese have gone through, although extremely compressed, is no different really than the maturation of most other countries over time. It just seems like it's been compressed over several decades rather than several hundred years.
Well, I mean, as I said earlier, you know, if you look back to the 60s with the Red Book and you look at how far China has come economically and in terms of their innovation infrastructure and their manufacturing infrastructure, it is just mind-boggling. It's just literally unprecedented in history. And so, you know, what I find so fascinating is how they have not only created this patent office with these examiners that can speak multiple languages. Remember, they're dealing with prior art in English and German and French, as well as Japanese and Korean. And you have examiners in the CNIPO who speak 2 or 3 languages fluently, who know the laws of these other jurisdictions at a level that is almost unbelievable. And they know all the key decisions of these jurisdictions, legal decisions. And if you ask the average non-Chinese, what are the top decisions in China from the courts, for example, Gene, or what are the code provisions in the China Patent Office, they just don't know it. So they've put a huge investment in understanding the world's intellectual property systems, and they've taken that and they've used what they consider the best pieces of it to build a system that in fact they consider far more effective and efficient than anybody else's.
Yeah, we have a comment here, and somebody says, "I hope you're not suggesting that countries become dictatorships or one-party rule or totalitarian." And no, that's certainly not what I'm suggesting. But I think if you don't understand that about China, then you're not understanding the full picture of how it is that they're able to move their intellectual property regimes so quickly. Because the leadership in China does seem to be all in on trying to make China a more patent-friendly uh, regime. The courts are moving in that direction, and for better or worse, I think the courts are influenced to a great degree by political movement in China, and the country is a one uh, party rule system, and they can change overnight. And if and Rob and I, we were just talking, Rob, maybe you can talk about this in the green room before the webinar, and that we probably are going to need to do this webinar again in 3 months. And certainly we'll need to do this webinar again after there's a trade deal. And this is a webinar that you could do probably once a quarter, because things are moving that fast. Now, how is it that they're moving that fast? They're moving that fast because they are a one-party rule country, and they don't have to go through those things like notice and rulemaking or a legislature to get things done, which right now, if you are pro-patent, is good. Now, if you're not pro-patent, that's not good. And it can be a double-edged sword, I suppose. Now, if you are saying, well, there's a double-edged sword, and I don't know whether this rug is going to be pulled out from under me. I don't know that that's waiting for that rug to be pulled out is the right approach, because as this Belt and Road Initiative gains so much momentum, and as people are given more rights and the companies and innovators are given more rights, it is going to be harder and harder and harder for any totalitarian regime to get into China and take all of that away. So I do think we are seeing a fundamental change in China. Not that we're seeing democracy, but I think a lot of what is being instituted is going to be extremely difficult, if not impossible, to undo. Rob, am I being Pollyannish there?
No, I don't think you're being Pollyannish, but I do think that the comment made by the listener is one that deserves additional discussion. For example, one of the things that we all need to be very concerned about is trade secret misappropriation and computer hacking, which, as we all know, if you believe what the FBI is saying and what the Department of Justice in the U.S. is saying, and the European counterparts are saying, and the Australian counterparts are saying publicly recently, is rampant globally. And you have government-driven espionage, if you will, and private parties and criminal parties that are engaged in rampant, pervasive computer hacking, Gene. And so a company, has to operate on the internet. And depending on who you're up against, you can have the best computer security in the world, and you still can probably be hacked at a very deep level by someone who really knows, or an entity that really knows what they're doing. So to me, we have this dichotomy globally in terms of intellectual property, where yes, we have trade secret laws, and yes, trade secret laws are being beefed up, but at the same time, the internet and the ability to hack has just gone up exponentially. And therefore, if you're an intellectual property owner, you have to be really worried about your secret sauce and all your most confidential information getting into the hands of your competitors and your imitators and, frankly, your counterfeiters. And therefore, if we don't look at the opposite of that, which is the patent systems around the world, we really are operating in a jungle, an international jungle of theft. And I guess what I'm really driving towards, Gene, is this is why the patent system may become more important globally, because there really is no other legal mechanism to protect innovators other than the patent system if all their confidential information can be hacked. And this is a real problem that is not getting better, it's getting worse. So I do agree we're dealing with a one-party system, and I'm not a Pollyanna about this at all. But innovators need to understand what they're up against, and the Chinese are going to go forward whether we like it or not.
Right. And the Chinese are always going to do what they think is in the best interest of the Chinese and of the Chinese long term. So you have to go into this eyes wide open, I think. We have a question here about prior art, and I think it's a good one. And this is something that you addressed in your article, and I want to make sure we get to. And one of the problems that we have is non-Chinese speakers do not have necessarily the easiest access to this. The PTO and others are trying to deal with this by using machine translations. But this is an issue. Now, one of the things that LexisNexis is doing, because the question is, China says another advantage China has is China is translating foreign patents into Chinese and other countries are not matching. Please comment. Now, Total Patent One, which is a product that's offered by LexisNexis here, our sponsor today, they are doing exactly that. They do machine translations of the Asian countries, the Chinese, Japanese, and Korean documents into English, but users can also search them in the native language as well. And LexisNexis IP is also in the midst of a project to reverse translate as well, and they are translating all of their patents that were originally filed in English into Chinese. So their translation is going both ways here. So there is an attempt here to deal with this issue, because this is an issue, right, Rob? I mean, the Asian languages are character based, and you have to know, and you have to, I think, you have to search it. I mean, maybe while we're talking about this, Gail, is a good time to push that other poll question about searching in Chinese. I mean, because we have a question here: Are you searching Chinese documents? Because there are millions of them. And Rob, what is your thoughts, or what are your thoughts?
My thoughts are that this massive filing that has occurred already and it looks like it's going to continue on, is a issue that I think crept up on the patent offices around the world and people using other patent systems, because it's unprecedented, just the sheer numbers of filings. And yes, you can argue, well, maybe many of them really aren't enforceable on their best day because they're clearly in the prior art, but they're still out there. And there's a lot of implications of this. It's not just a prior art issue, but it's also an issue, Gene, of if you enter China, and what patents are going to be asserted against you by your competitors in China in the Chinese courts. I mean, it's not just a one-way street where you're trying to protect your product in China using your new Chinese portfolio, but you could find yourself on the receiving end, and this, by the way, is predicted by a lot of leading Chinese lawyers, by the way. You could be on the receiving end of a massive counterattack with all of these patents that have been filed as the basis for that counterattack by the Chinese competitor. So the language barrier is huge for most companies. They don't have people that speak Mandarin. I know in our law firm, we've got 6 or 7 that speak Mandarin, but even still, I think the patent offices are woefully equipped to deal with this issue. And machine learning is one thing, machine translation is one thing, but the idea of understanding what's really going on in China is something that I think the other patent offices are scrambling at the highest levels to get on top of, because think about it, Gene, if you have 50% of the filings globally are in China, how does a global patent system effectively work if you're not searching 50% of the filings that are taking place.
Yeah, I know. And did you just see the results? Over 50% are not searching Chinese prior art. Now, I get it. I get it on some level, right? There's only but so much searching that you can do. And it was a nebulous question, and on some level, because we didn't say searching for what purpose, right? If you're searching to file an application on the front end, you have no idea whether that application is going to be for something that is going to be useful or useless. And most of the time, it's going to be for something that's useless. But you're filing the application. Maybe it'll be useful for funding, maybe it'll be useful for PR, but it's not going to be useful in the commercial economic sense. So you do a responsible search, but that responsible search, I think, increasingly is going to have to include some Chinese data, the database, right? Because it's like you say, if half of this stuff is going to wind up being Chinese, and you're not looking at half of it. Oh, I mean, this is a problem, and this is obviously why LexisNexis is doing something about this, right? I mean, they would not be investing the money to translate and reverse translate if this wasn't an issue. I mean, and your quote here, just let me say that I love this quote from Isaac Newton. You standing on the shoulders of giants, and then your quote, this Chinese prior art library may well be those shoulders in the years to come.
Yeah, and what occurs to me is we all need to be thinking about this also from the perspective of validity, because we all know that if you have a global portfolio, what happens in terms of a validity challenge, say in the Federal German Patent Court or the PTAB or the equivalent at the JPO, is going to have a ripple effect, if not a fundamental impact on the validity of the counterparts in these other jurisdictions. And it turns out that the Chinese have moved very rapidly along the lines of our PTAB, which I didn't understand until a week ago. And there is a section of the CNIPA called the Patent Unification Panel, where they convene 5 examiners, Gene, to review the validity of a patent being enforced in the Chinese courts, because the courts do infringement like they do in Germany, the regional courts that they've set up. But the validity issue is addressed back at the CNIPA in a very fast fashion. I'm told 6 to 9 months is the time frame for this validity challenge, which takes place. And going back to your injunction point, they've tested the validity. So by the time infringement has been found, you don't have the same kind of injunction gap you have in Germany because of the speed of this. And therefore, they've improved on this German system. And this is probably why you get injunctive relief. But again, you can assume that if you're going to go enforce your patents around the world, particularly against a Chinese company, they're going to produce Chinese prior art to be used against you, say, in Germany or the US. Now, it's one thing if the innovator you're up against or the competitor you're up against is behind you technically. But if this 5-year program, which is targeting these 25 leading edge technologies, and they are the most important technologies of the future, if the Chinese innovators get ahead of the rest of the world in these technical areas, then you could see how the Chinese prior art, Gene, could be even more important for validity globally than any other prior art, because that's where they're going to file first. So right. This problem is not going away. It's going to get worse.
It's going to get worse, and you're going to need to have solutions to deal with it, and deal with it quickly, because you're going to need to have at least reasonable answers for clients within their budget. Now, this is, I always talk to people about this, and a lot of times people mishear what I'm saying, and attorneys will say, well, I can't do the work if the client's not paying me. I get that. I completely understand it. I am not telling you to do a $10,000 application for $5,000 or to do a $5,000 search for $2,000. If the client's going to pay you $2,000 to do a search and give them an opinion, then you're going to give them a $2,000 product. Now, what you need to hopefully do is leverage the tools that are out there that can get you to the answer for the client's budget. And that's what I think we need to increasingly do. And those tools are out there. And I think Total Patent One may be one of them. And I would encourage you all to take a test drive. LexisNexis will give all of you a test drive. They'll give you all a demo and at least try it. Give it a try. Because it's a massive, massive problem. Now, Rob, we do have a question here. We got a lot of questions. Unfortunately, we're not going to be able to get to all of them. We're going to have to circle back and do this webinar again. But one that's really interesting, we have a US-centric company, and they're using US patents as a firewall for Chinese products. What is the feasibility of that strategy going forward? And I guess maybe just if I were going to add to the question is, should they also be thinking about getting Chinese patents? Now, I have a feeling, but I'd like to get your take on it first.
Well, I think that this person is really on it, because many companies, as I said earlier, have told me behind closed doors, look, we're not going into China. We can't play that game. We're doing just fine in Europe, or we're just doing fine in the US, or we're doing just fine in Japan, and we really are not big enough, or we just don't want to enter that market. So how can we protect ourselves from products coming from China into our jurisdiction? And therefore, you have to, of course, have a very strong domestic patent portfolio that you have crafted with high quality, Gene. This goes back to your budget point. This is where the money should be put. First and foremost is to build a very strong patent portfolio in your own jurisdiction that you can use to protect yourself either at the equivalent of the International Trade Commission or in your courts, and also survive validity challenges that are inevitably going to be brought by the infringer if they're well heeled, and many of them are extremely well heeled, because when you trace back a couple of companies that, interlocking companies, you discover there's big money behind them. So I would say that the bulk of the investment should be placed there. But I also think that a strategic filing program in China needs to be looked at immediately. And the reason for this is having a few patents in China that are really good seems to me to be a very prudent precautionary move in this present evolving environment, because if you have nothing in China, like many clients do outside of China, frankly, because the bulk of the Chinese filings are Chinese, to me, that gives you no leverage against the Chinese in their own market. So you may be able to use your Chinese patents to go to the source of manufacturing, or to go to these competitors and take the fight to their jurisdiction as a way to protect yourself in your own jurisdiction. Does that make sense?
Absolutely, and that was exactly what I was going to say. I think increasingly U.S. companies and innovators need to be looking outside the U.S. And we did I teach this patent course for new practitioners, and we do we call it monthly mentoring sessions. And the question we just got earlier, actually, I guess it was earlier this week when we did one of those from somebody is what do you tell clients who have a software related invention in the US? And I, tongue in cheek said, I tell them to go to Europe and China. And, and that really is not as tongue in cheek anymore as it may seem. It's sure file in the US. Because the one thing we know about software in the US is the advice that we've given clients has never been the same for more than about 2 to 2.5 years. The law is always changing. and there's no reason to believe that that's going to be different. So what we do know is when you file a software application in the U.S., the law that is going to be used to examine that application is going to be different than what it was when it was filed. We know that for sure. But in Europe, there is a target that we know and it's been certain. We can argue around the edges, but we know what the test is. And in China, there's a lot more of this stuff is eligible, as we have a slide here to explain. And I think you need to be looking outside the US and certainly to China, and I think also to the EU, although that's not our main topic for today. But you wouldn't go to those places unless you're a big multinational with all of your filings. I think I really like what you said. Pick the cherries off the top, the stuff that matters the most, and file high quality. I would rather see people file high quality in the US and not worry about accumulating so much. Because what you want to have, if you talk to the monetizers, is rather than having a big portfolio, what you want to have is a portfolio of assets that are infringed. Now, whether or not you're going to sue anybody or not on those assets, they're valuable if they are infringed. That's what creates licensing opportunities. That's what creates the opportunity to sue in court. And that's what creates investment opportunities. That's what creates people wanting to acquire those rights, et cetera, et cetera. But you'd be better off having a dozen, 15 or so high quality assets that are infringed than having 100 that are kind of middle to lower quality that maybe they're infringed, or maybe they're definitely infringed, but they're middle to lower quality. I mean, that doesn't excite anybody in this marketplace. So I think you want to look at the top and go to the source. That's different than what the advice used to be. But right now in the US, yes, the ITC you can go there and you can get some good results in stopping the stuff from coming in, but much faster outside the US, much faster in China, much faster in Germany, but it's even faster in China than in Germany. And that's just the reality we live in, right, Rob?
Yeah, and as we all know, if you're playing a global game, which many companies are doing, or whether they like it or not, the idea of just limiting yourself to China and the U.S. is not necessarily a good idea either. For example, Gene mentioned Germany, and post-Brexit, the U.K. Both those jurisdictions need to be looked at. The Netherlands needs to be looked at as well. Japan, perhaps. South Korea, perhaps. The important thing is that it used to be that the Eastern District of Texas or the U.S. patent system was the place everyone went to because it was fast. It was, while it was expensive, it was fast. You could get injunctive relief, Gene, and you could get serious damages. Now, as you point out, the whole thing has gone global. You go to Germany or China for injunction. You maybe go to the U.S. for damages down the line. But everything has to fit together. And this is why this prior art issue is of such great concern to me professionally, as someone who deals with a lot of validity fights around the globe. You know, how do you make sure that there isn't prior art working in China now that you don't know about that could really blow up your entire global enforcement program, Gene, and frankly could be copied. The prior art could literally be invalid, but it's still prior art, and it might be the best prior art out there because what was copied was so understandable that people hadn't filed on it in other jurisdictions. And when you look at the amount of prior art, for example, in the EPO or in the US or in Japan or in Korea, compared to China, it is a very, very big problem. And I'm very pleased to hear that, and I didn't know this, that LexisNexis is going after this issue, because I don't think we can count on our patent offices to do this job. I think it's going to have to come from the private sector, this translation issue.
I agree with you because it's a big project and it needs to be done quickly. And those two things don't go very well when you're looking at government, unfortunately. But just to put a bow on it, for those of you who may not understand why Rob pointed to the Netherlands specifically, because that's, to some people, that means, well, why would I want to get a patent in the Netherlands? Well, the Netherlands scores very high on the patent system grades from WIPO and also from the U.S. Chamber of Commerce every year. They have a good rules, and they have the ability to get an injunction, and they also have the Port of Rotterdam. So there's places around the world where you may not think about getting a patent, that I think you need to expand your horizons. China is certainly one of those. If you're not giving advice, you're not thinking about it, but there are a few others. Now, the Port of Rotterdam, not everything goes in and out of the Port of Rotterdam, but those things that do come in and out of the Port of Rotterdam, if your clients are working in areas where the Port of Rotterdam does shipping, you should be getting a patent there. But that's a different conversation for a different day. We have a question about, is the patent system designed to favor Chinese applicants rather than foreign applicants, such as U.S. companies enforcing rights in China? Now, from what I understand from the people that I've talked to, Judge Rader and others, not just Judge Rader, but I've asked that question to multiple people who I know are engaged in litigation in China. That may have been the case once upon a time, but I'm told people are not afraid to bring actions in China where there is a good patent that is being infringed. So things are changing. Rob, is that your understanding as well?
Yeah, I would agree with that, but let me put a little bit of a nuance on it. From what I've been told, we have a trade war going on, or maybe a trade adjustment going on between these two big superpowers, because frankly, China, in my opinion, is the new IP superpower. And therefore, the Chinese have gone out of their way to build a court system and a patent system that is very pro-innovator. Now, the question becomes, though, what if you're dealing with a technology that is very important to the government for strategic issues, whether it be defense or whether it be the 5-year plan, for example? And what I've been told is, depending on who's on the other side of the lawsuit, Gene, it could make a big difference.
Yeah.
And it also, and China is a huge country, and people point out to me, it is a huge country. So the way the courts operate in one part of the country is not the way the courts operate in another part of the country. And while there's like 20 some courts where you bring first action infringement cases, and then you have the appeals courts in a fewer number of cities, and then you go to the Supreme Court in Beijing, where you have specialty Supreme Court judges who understand patent law and technology, which doesn't exist anywhere else in the world. And you have judges like that in these other levels of the 3-level court system. Nonetheless, you need to be very concerned about being hometown. That doesn't mean you shouldn't do it, but you should be concerned about being hometown. So you need good advisors. In my experience, you need really good advisors who understand what's going on, because this is a very large country. And yes, everything goes to Beijing, but Beijing, frankly, is not controlling all these regional courts and all these judges. It just is not happening.
So that's an interesting question. One that we were talking about that we're not going to get to do justice in the last 6 minutes that we have. But I was just speaking at an event in Dublin, Ireland, put together by the European Patent Office. And the best way to describe it very quickly was it was for high growth SMEs, and it was a bunch of experts who had something interesting to share with these SMEs. So it was a series of vignettes, and it was excellent, very well done. And one of the vignettes was a guy who was himself a CEO of an SME, and he got up and he said, a year ago, I didn't know that there were people who their job, their profession was facilitator in China. And he said, today, I couldn't imagine doing business without doing business with such a facilitator. Now, that's not exactly what you're talking about, Rob, but there are people when you're going to China that have that knowledge, the peculiar knowledge of the local market, the manufacturers, the court system, and you need to work with those people because, yes, China is changing. So the question supposes, I think, that US companies can't get a fair shake in China. I don't think that's true. But is it the democracy that the blind democracy that we come to um, know in the US? No, China's not there yet. But if you have people helping you navigate the system, the legal system, and the economic and business side and the manufacturing side of the system, you're going to be much better off. Not only much better off, is probably really realistically the only way to successfully do business in China and to do legal business in China. So I think you need to understand that if you're going to be working in China. Rob, we have a couple questions here before we wrap up that all sort of get around. We talked about when you were mentioning the Belt and Road Initiative, you were talking about the technical areas that China's focused on and the plan that they have. Can you explain which technical areas China is really investing in?
Well, this is the artificial intelligence, of course, is at the top of the list because AI, and this is a topic I've been involved in 30 years, for 30 years now, but AI has the potential of really changing the ability of computer technology to all application areas in human endeavor. I mean, it can have a fundamental impact on any technology area. So that's one area that they're putting a lot of emphasis on, but you can imagine what the other 25 are. I mean, we're talking about electric vehicles, we're talking about battery technology and material science, biomedical engineering, telecommunications.
5G is
right.
huge,
5G is huge. And essentially what they've done is they've done a very careful analysis of where the futurists say things are going. And you can obtain this document. Gene, I think we provided a link for that. You can obtain this 5-year plan in English, and you should read it because it's broad-based in its description of what they're trying to do. But if you're in a leading edge area of technology, you should assume that the Chinese are coming, or they're already there. And therefore, you need to think globally when you're putting together your IP strategy and your IP implementation of that strategy, because they are no longer wanting or willing to be imitators. They want to be the innovators.
Yeah, and here's the article that was the genesis of this conversation, and I've kind of cannibalized it across all these PowerPoint slides. I would encourage everybody to go and read it. It's not terribly long. It's a good read. It's very informative. Like Rob said, it has links there to more information in English. So I would encourage you all to go and take a look at that. I think it's very well written. I liked it. That's why I asked Rob if we can publish it. It was a version of this is what he had sent out in his newsletter. And if you're not getting his newsletter, you should. I mean, everybody in DC I think anybody is getting your newsletter. I know I get it, and I look at it all the time. So sign up for Rob's newsletter. Looking at the clock, we got about the final minute. So, Rob, in the wrap up here, what is the one or two things that you want people to leave this webinar remembering today?
Number one, China is something you need to put a lot of focus on right now. And number two, you've got to think global in terms of IP today, even if you're operating in a geographical area only. Those are the two thoughts, Gene.
Yeah, and I couldn't agree more. I think you ignore China at your own peril. Now, that's not to say, like I said at the beginning, that China is the, Shangri-La. It's not, the end all be all. It has some issues, and you're going to need help navigating the Chinese system. But if you're not looking to China right now, and seeing how you can fit in, I think it's a mistake. Several years ago, it was if you didn't have an Indian strategy, the VCs weren't talking to you. They didn't want to hear from you. I never really understood that. I didn't get that because I didn't think India was gonna take over the way that China would. And that's a longer conversation for another day. India obviously has a very important economy, world economy, but I fundamentally do think that when we are all at our retirement parties looking back, we will say that China, for better or worse, did change the global IP system. So it's time to get on board. And that's all I have. And I really appreciate you all spending some time with us today. And of course, I appreciate LexisNexis IP and Total Patent One for sponsoring this webinar. So please give them a test drive. If you're interested in this topic, you're going to need to know what they're doing here with the Chinese translations. So I'm sure they'll give you a demo, so you can reach out to them here, and Morgan will be happy to set you up. So thank you, and we will talk to you all soon. Thanks, Rob.
Thank you.